Hey everybody, today I wanted to talk to you about how to transfer your primary residence into your revocable living trust. But before I do that, I wanted to let you know how to reach out to me. You can find me in my email, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me at my website, www.legionlawpllc.com. So with that, let's dive into this extremely important topic. And the reason why it's very important is because if you do not transfer your house into your trust, the house will be subject, most likely, to probate. And probate is not fun. I've talked about this extensively in many videos, but probate tends to cost way more than setting up the trust, let alone it takes 3 to 4 months to transfer the property. You have to work with mortgage companies and real estate. It's a disaster and a half. So, in this particular case, you've already created your trust. It's a revocable living trust, and you want to transfer your house into it. So how do you do that in Texas? Well, my recommendation is you go to an attorney, like myself. Usually estate planning or title or real estate attorneys can do this, but they will prepare a deed for you. And this deed is going to have 2 important sections. It's going to have the grantees and the grantors. The grantors are the people who are giving away the property, who are selling it, if you will. And the grantees are the ones who are receiving the property. So the grantors are going to be you, and you're going to be the grantees, but the names are going to be different. And here's how I explain that. So under the grantor section, it's going to say Derek Christensen as sole trustee of the Derek Christensen Trust dated whatever. No. The grantor is going to be me individually. So I apologize. Back that up. It's going to say Derek Christensen as an individual who is married and has this address and blah, blah, blah. Then the grantee section is going to say what I just said, which is going to say Derek Christensen as trustee of the Derek Christensen Trust dated whatever, which has a mailing address of whatever else. And the reason why is because you're going to be transferring it from your right pocket into your left pocket. You're going to be saying, I'm going from an individual owning this house to as a trustee owning this house. And really, nothing else changes in your life. You can still drive your cars, you can still own the house, you can sell it, you can do whatever you want. But at the end of the day, the fact that you changed it from your right to your left pocket, the left pocket is protected from probate, the right pocket is not protected. So really, it's that simple. You need to get that deed signed, you need to get it notarized, and you need to get it filed. Now, in Texas, I don't know about preparation of deeds. I'd be shocked if they allow normal, everyday people to prepare deeds, but I do know that in Texas, there are particular businesses that are allowed to file deeds. Only they can file those deeds. So law firms, title companies, mortgage companies, real estate brokers, I think, something like that. But there's a specific criteria of you must be one of these people in order to file a deed in the county record. And once it's filed in the county record, going through one of those businesses, then that deed is going to become effective the moment it's accepted by the county. And once it's accepted, then that house is officially inside the trust. So it's really quite simple, but it's a little bit more complicated than you would think. So it's simple in the fact that all you really need to do is sign a 1-page document, a deed, and it transfers it from your right pocket to your left by using the specific language I just mentioned earlier. However, once you sign it and notarize it, you got to make sure it's filed correctly in the right county using the right language, and once it's filed, then it's effective immediately. So if you do not file it, it does not count. So a signed deed is not effective. You must file it because everybody else needs to know what's going on. Now, a couple more points to make to that. You're pretty much going to have to work with an attorney. I would be shocked if an attorney would be okay with accepting someone else's deed that they've drafted off the internet or themselves. More likely than not, you're going to have to use the attorney's deed because the attorney will understand that deed much better than anything you can bring them. So my strong recommendation is simply just start the whole process with an attorney. It really shouldn't be too bad. It should cost under $500 to get everything done correctly and filed. And it shouldn't be terrible. So if you do that, your house will avoid probate, and that's fantastic. And if you don't, then your house is just like it always has been. It's not going to avoid probate. It is subject to probate. And as a side note, probates almost always escalate and get worse and more expensive and slower if any real estate is involved. So that's the problem. So make sure you always take care of your real estate and make sure you always transfer it into a trust. Now, 2 other things. 1, if your mortgage company tries to say the due on sale clause is activated, you transferred it to someone else, therefore you owe us all this money now, that's not allowed, at least for your primary residence. It's not allowed, and there's something called the St. Germain Act, which means that you're protected from transferring your property from yourself to your revocable living trust. You should not get a bill. You should not owe your entire mortgage immediately. And if that is the case, get an attorney and go slam the book on them because that mortgage company would be wrong. The second point to make is that you may not want to do this if it is a rental property. You may want to as well, and in fact, if your rental property can get transferred into a trust, I recommend that. But sometimes the St. Germain Act does not apply to certain properties, and that may include rental properties. And if the mortgage company is getting really frisky, they may force you to sell or pay for the entire mortgage up front right there. So you might want to just double check with an attorney on that. It's rarer that that's the case, but I still recommend you should look into the option of strongly considering getting your rental properties in there as well. Again, all rental property or all real estate inside trusts is better than outside trusts most of the time. So again, talk to an attorney, figure out the pros and cons, and again, if it's your primary residence, do it. Command form. If you have a trust, it is not worth anything if there is no house inside of it that you do when you do have a house. So if you have any questions on that, feel free to email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can go onto our website, onto the Contact Us page, and schedule a consultation for free over the phone directly onto my calendar at www.legionlawpllc.com. So with that, thank you so much for watching and have a great day.